Good morning, everyone. You've tuned into Buy Now, Sell Now on ET Now. I'm Karunya Rao, and let's straight talk about the biggest story of this hour, which is the fact that the Supreme Court has struck down RBI's Feb 12 circular on resolution of stressed assets. Let's take it across to Ruchi to fill us in with all the things, all the latest developments that we need to know. Ruchi?
Absolutely. If you look at the kind of announcement that has come in, the Supreme Court quashing and really setting aside the February 12th circular, it really is a big setback to the entire IBC process while we are awaiting final words from North Block. But remember, the Finance Ministry had sought some sort of a differential approach from the RBI with respect to the stress in various sectors, especially the power sectors. And which is why, remember, power companies along with Power Association had reached out to the Supreme Court to really look ahead. Remember, it is really that one-day default norm, which was a big pain point, and needs to be seen what happens to the 75-odd companies that are in the NCLT. The Finance Ministry as well as RBI are awaiting that order copy, but we have been speaking to a lot of senior government officers as well as senior people in the RBI, and our sense is that perhaps the RBI, because Shaktikanta Das, the new RBI governor, had in fact also backed the February 12th circular, needs to be seen if the RBI will reach out to the Supreme Court once again. And this is coming in on the heels of, remember, the government also asking the RBI if a differential approach can be taken for various sectors, but looks like now they really have to find a way out as to what needs to be done. I'm also joined by, on the phone line, Nilang Desai. Mr. Desai, thanks for speaking to us at ET Now. Let me first begin by asking you, how are you looking at the Supreme Court's verdict that has really come in, calling it the February 12th circular unconstitutional? What happens to the IBC cases in your view now?
Well, cases where IBC has been filed under the Feb 12 aegis, now technically the borrower can go in and say that this filing should not be made, and the court can throw it out. Now, remember, in a lot of these cases, there already will have been defaults, etc. So the banks are still entitled to go under the IBC should they wish to. The only thing that changes now is, while the banks retain the right, they are no longer obliged to. And the question is now, while banks were rushing to court to put companies into IBC because of the circular, what is the timing for them now? Will they give them 3 months, 6 months, 9 months, or 5 years?
In terms of the timeline, you hit the nail on its head. Do you believe this is really going to delay the entire IBC process? Because up until now, there was a set timeline, but now with the Supreme Court calling the February 12th circular unconstitutional, it really puts to risk some of those IBC cases. The banks were hoping that money is going to flow in, but now it looks like, in terms of the timeline, we are all set for a delay.
So just to bifurcate the issue, this does not affect the IBC per se. There are no delays in the IBC caused by this. What this changes is how quickly the NPL issue in India gets resolved. While with this circular, there was a chance that it would get resolved very quickly because many companies would go in and out of the IBC. Now, with the banks potentially giving their borrowers more time, the resolution may take more time. The IBC process per se lives on, no issue there, no change.
Right. Mr. Desai, is it also a wake-up call, so to say, for the RBI to recognize the stress that is there in various sectors due to very many reasons? Because up until now, the RBI was hell-bent that there is no need for a differential approach. North Block was pushing for a differential approach, but the previous RBI governor, Urjit Patel, as well as the RBI governor now, Shaktikanta Das, they were backing the February 12th circular to 10 nail. But perhaps, do you believe it calls for a differential approach, a need by the RBI to relook at the entire process once again?
Well, I think we'll have to read the judgment on the circular to see on what basis they regarded this approach unconstitutional. Because until now, the court has been taking the view that in functions such as this, they will defer to the regulator and not interfere. So I think it really bases that we have to think about how the RBI may, revisit this issue, whether it segregates, whether it gives more time, or whatever else it needs to do to be compliant with the Constitution.
What happens to the schemes which earlier the RBI had really done away with, the S4A restructuring method as well as CDR? Because once the IBC process came in, all these schemes were really done away with by the RBI. What happens to those schemes? Do you see these schemes coming back, and perhaps the RBI now looking at different ways to empower banks to be able to get their monies back?
Well, very technically you're right, because it was this circular which took all those schemes out. So effectively the schemes now, have had a rebirth. But of course it's open to the RBI to pass another circular tomorrow to cancel those schemes. Again, we'll have to see what the Supreme Court has said. I don't imagine what they've said is that striking off those schemes was unconstitutional. So the RBI can still strike those schemes off and say, no, IBC it is. It's just that the mandatory nature of the February circular will have to be rethought.
Absolutely. Mr. Desai, just quickly before I let you go, do you see the RBI now going to the Supreme Court once again and perhaps asking for a bigger bench to relook, at this order? Do you see that happening?
Very frankly, it really depends on what the order says. If the order comes out and says minor tweaks can fix it, maybe they make those minor tweaks and move on. If there are more significant constitutional changes, maybe the RBI rethinks its approach. I really don't know, whether they will appeal to a constitutional bench without having a look at the order.
All right. On that note, Mr. Desai, many thanks for joining in, taking your time out and making sense of those developments. Remember, the Supreme Court has set aside the February 12th circular. It's a huge setback coming in for the IBC process. Needs to be seen whether the RBI will go back to the Supreme Court once again to relook at the order, while Finance Ministry is still awaiting the order copy and will make sense of those developments only later. They were asking the RBI for a differential approach, and the RBI had completely ruled that out. With that, it's back to you, Karunya.
Thanks, Ruchi, for getting us those all important details that everybody needs to know.